Afternoon. Now joined by our chairman of Blockchain Capital Finance and Digital Innovation Technology, Chairman Olson. Welcome to Corporations. We're here to talk about Senate File 55, the Insurance Sandbox.
Thank you, Mr.
Turn it over to you.
Yeah, thank you, Mr. Chairman. I'm sure my members of Judiciary are very pleased that they did not see this bill today. So we had a blockchain bill in Judiciary this morning, and it's always a little different for them. But this bill landed in the right place, Mr. Chairman, as it is more of this committee's bailiwick than it probably is even our own. So I'll walk you through the bill, Mr. Chairman, just kind of backing up, real quick explanation, although I'm sure the members of the committee understand what a sandbox is. This is simply an attempt to create a box for interested individuals in the industry to play within, to be innovative, to bring new ideas and new businesses to Wyoming. This committee may recall that Wyoming has created two previous sandboxes, a medical technology sandbox and a financial technology sandbox. So this is one more tool that, at least from the perspective of the select committee, that we believe could spur interest in Wyoming. And with that, Mr. Chairman, I'll just walk you through the bill. Mr. Co-Chairman.
Happy to be here.
Thank you for joining us. I actually was just getting ready to walk through the bill. If you had any opening comments, no? Okay. All right. So on page 2 through page 3, we walk through the definitions that are created under the Insurance Sandbox Act. Consumer is any person in Wyoming who purchases or enters into an agreement to receive the product. That's pretty straightforward. Innovative is more obviously to appease the makers of the bill. What does that mean? It means emerging technology, existing technology to address a problem and provide benefits otherwise not provided to people. Insurance Sandbox, down in the middle of the page on page 3. What is this? It is a sandbox. It allows a person to make an innovative insurance product or service available to consumers during a sandbox period. We'll see that later in the bill. That's, well, actually, I guess it's right below. It's a two-year period through a waiver through the insurance commissioner under the existing statutory and whatever rule requirements may develop, or any portions thereof developed by the commissioner. So what is that sandbox period, Mr. Chairman? I just referenced it. It is an initial 2-year period. We'll get to a place in the bill where that can be extended for up to an additional 1 year. But initially, we're allowing these innovators to play within the box for up to a 24-month period. Page 4, Mr. Chairman, we now are out of the definitions and we are to the waiver, the Insurance Sandbox waiver. Middle of the statutory subsection A reads on line 11, a waiver under this subsection shall exempt no more statutory or regulatory provisions than absolutely necessary to accomplish the purpose and standards set forth in this act. This is the box. This is the line in the sand, if you will, that's being drawn, that we are saying you may play within this box. Now, what does that mean for each individual applicant? You'll see below on page 4 and on to page 5 and continuing to page 6, 7, 8, the statutes that I'm sure, Mr. Chairman, you are intimately familiar with. But these are the provisions that may be exempted. They're not always all exempted, but the point of this language that I'm pointing you to, Mr. Chairman and committee, that the waiver under this subsection only exempts out what is absolutely necessary. So the goal, of course, of this application is not to have some individual or entity come forward and say, we just want to be exempted from the entire insurance code. I hope that's really clear. That's not the intent. In fact, if we pass over through those statutes that are being exempted and we get into the application, you'll see, Mr. Chairman, that you have to very specifically delineate what you want to be exempted from and why you believe your innovative product would not otherwise be permissible or thrive under that regulation. So on page 9, Mr. Chairman, this is an important part of the bill. Subsection B at the top of page 9, a person who makes an innovative insurance product or service available to consumers pursuant to this chapter is A, not immune from any civil damages, and B, subject to all criminal and consumer protection laws. Subsection C there allows the commissioner to refer any suspected violations to any appropriate state or federal agency for investigation. So it doesn't fall necessarily strictly on the commissioner. If it falls outside of his or her realm, that investigation may be referred to whatever entity for prosecution, whether that be civil or criminal, or just, I should back up and say investigation. Page 10, Mr. Chairman, subsection E, no waiver or element of a waiver shall be granted under this chapter if the waiver element would jeopardize the state's NAIC accreditation. This is a very important provision. I'm sure the department, if you ask them and if they speak to this, they will say this was absolutely an ongoing conversation, that when we started the conversation on the sandbox, actually, let me back up, Mr. Chairman, that was the concern of our good department. Will we jeopardize the NAIC accreditation? So we want to make that very clear. Anything that the commissioner in reviewing an application believed that it would in fact jeopardize that accreditation, that application should be rejected. Page 10, 2655 104 insurance sandbox. This is the actual application process. I referenced this earlier, committee. A person, when they apply, the person on line 11, the person shall specify in an application the statutory or regulatory requirements for which a waiver is sought. So why am I seeking it? And the reasons why. Why the requirements would prohibit the innovative insurance product or service from being made available to consumers. Very specifically, tell us why you should be exempted. No, you cannot just exempt yourself out of the insurance code just because. Bottom of that page tells us that a person may apply, Mr. Chairman, even if they don't have currently a valid license, but that if they pursue that route, the application submitted, of course, they must, in order to have full and complete consideration, they must have a valid license and obtain one. Really like on page 11, subsection C, and I think this committee will appreciate this provision, must be a business in Wyoming. A business entity making an application under this section shall be a licensed domestic corporation or other licensed organization, organized domestic entity, with a physical presence in addition to that of the registered office or agent here in Wyoming. So I want to impress that upon this committee. The object of this bill is to attract business to Wyoming, to spur innovative ideas and to encourage them, but it is certainly not to farm out the good laws of our state to entities afar or offshore that may have interest in availing themselves under our laws, but no real interest in being a stakeholder in Wyoming. This is intended to make sure they are in fact, like all of you, physically located right here in Wyoming. Bottom of page 11, an application made under this section. Oh, this is the fee. And Mr. Chairman, my understanding is in the Senate, this fee was increased to $5,000. This is the fee for the application. The language that follows, actually it's later in the bill. This goes to the administration of the application. Even if your application was denied, there's some language in here that makes it very clear you don't get your $5,000 back, because there is quite a process that goes into reviewing these applications and processing them. On page 12, the commissioner shall approve or deny any application within a 90-day period. The commissioner may impose conditions on any application, may make it conditional for approval, consistent within this act. Then what follows, Mr. Chairman, from this provision, subsection F, is what the commissioner must consider in making his or her decision. So the commissioner shall consider each of the following. And the first prong is the nature of the innovative insurance product proposed, its availability to consumers, including all technical details. On page 13, you'll see some, this is where we start to get into consumer protection. There's a balancing act here. Any potential risk to consumers and methods that will be used to protect consumers and resolve complaints during the sandbox. First piece of consumer protection. Second, a business plan. That seems rather straightforward. Whether the applicant has the necessary personnel, financial and technical expertise. Romanet 5 is a criminal history, Mr. Chairman. If they are currently under investigation for fraud, state or federal insurance violations, or any property-based offense, that needs to be part of the application, and the commissioner certainly must consider that. Disclosure, going over page 13, onto page 14, ending with any other factor that the commissioner determines to be relevant. If the application is granted, that's subsection G. If an application is approved under subsection F, everything we just went through committee, the commissioner shall specify the statutory or rule requirements or any portions that are being waived or exempted out. What the period of time is, doesn't have to be the full 24 months. And then the rest of that language talks about how the department's going to post this on their website. Subsection H is the bond. This, I believe, was also increased by the Senate. An applicant must post a bond. This is another piece of the continuing on our Consumer Protection Committee. Page 14 on the top of page 15, you'll see the bond there on line 4, $100,000.
As the minimum.
Is the minimum bond. Thank you for that clarification. That is a minimum, not less than $100,000. Continuing down to our new statutory provision being created, 2655-105, the insurance sandbox account. We are creating an account. This is simply to cover the administrative costs. I referenced this earlier. Monies under this act are being deposited into that account, and you'll see on page 16, line 6, these funds and any additional funds appropriated by the legislature shall be used only for the purpose of administering this act, including processing of the sandbox applications, monitoring and examination enforcement of activities related to this act. I'm sure your good department can testify as to the manpower and the time that would go into these applications. That is in part why the application fee needs to be as significant as it is. The other piece to the, and my co-chairman could probably speak to some of the discussion on the other side of the chamber, but the other reality of having a high bond and a high fee is you want serious players. We want serious players if we're going to spend the department's time to walk through an application. Bottom of page 16 is the operation of the insurance sandbox. Subsection B, the commissioner may on a case-by-case basis specify the maximum number of consumers permitted to receive an innovative insurance product. More consumer protection also built in to the idea that if we're going to exempt, there's a give and take. If we're going to exempt you out of certain areas of the statutes, we do need to make sure that the commissioner has the authority necessary to place additional limitations as we move forward through this process, that being one of them. The other one is on subsection C, which is on page 17, Mr. Chairman. Before a consumer purchases or enters into an agreement to receive an innovative insurance product or service through the insurance sandbox, the person making the product or service available shall provide a written statement of the following. And then what follows are disclosures, name and contact information of who's making the service. We know exactly who they are. Product, what is the product or service that's being authorized? What is the period of time it's being authorized for? Very specifically, at the bottom of page 17, a disclosure statement that says that the state of Wyoming does not endorse the product or service, and it is not subject to liability for losses or damages as a result of any product or service. Other disclosures, the product or service is undergoing testing, that the person making the product or service available to consumers is not immune from civil liability, which we discussed earlier. They're not exempted from any criminal liability. The expected date of the sandbox period. And you can read through some of the additional disclosures. Mr. Chairman, I don't have to belabor that. Commissioner has authority to examine any records maintained under subsection D above. That was that's all of the disclosures, which have to be held. Those records have to be kept for not less than 5 years after the conclusion of the sandbox period. Mr. Chairman, 3 more statutory provisions. I will try to move along here. Page 21, 2655-107 provides the commissioner the ability that he may, by order, revoke or suspend any person granted authority to operate inside the sandbox. If they have violated or refused to comply with any portion of this section or any other lawful rule, order, or decision that is in the state of Wyoming or by the commissioner. On page 23, 26-55-108, the extension of the sandbox, I referenced this earlier, committee. The period of the sandbox is only for 2 years, but a person granted authorization under this act may apply for an extension of an initial sandbox period for not more than 12 additional months. Page 24 is rulemaking. 26-55-109, rulemaking authority for the commissioner to adopt the rules and regulations necessary to implement the sandbox. Section 2 on page 25, appropriation of $500,000 from the special revenue funds that are generated by the department to start funding the administrative process of receiving those applications and any enforcement necessary while we wait for those application fees to build up. And then section 3 and section 4, as you know them, Mr. Chairman.
Okay, questions, committee? Okay, we leave a vote. Major, I guess my main question is, did some type of innovative company come to the committee and say, hey, we want to experiment in this area? And are they a public company, or is this something that's happened in other states? I know we've been kind of the first sandbox in a couple of other areas. Are we the first insurance sandbox to allow people to test our laboratory of democracy?
Chairman, to address that question, there are other states that have insurance sandboxes, but not as comprehensive and not structured similarly to what we have here, which was based on the FinTech sandbox we did a few years ago. And, I think it's very robust and a good model for us to follow. With regard to the impetus, a little over a year ago, so just a couple of months prior to the last legislative session, too little time to take any action, we were approached by the reinsurance industry. And there was a request to explore ways that we could reform our statutes or put in a sandbox to provide that flexibility so that they could explore bringing reinsurance to the state of Wyoming. You saw in the House legislation that actually addressed a lot of those concerns. We were already working on the sandbox concept because we thought it was a good idea. And what we realized was that while we had a piece of legislation that would directly address the concerns that were raised, it doesn't mean it was an exhaustive list of concerns. So we wanted to provide the flexibility, and we felt it was important for us to bring forward the sandbox so that if there were additional parameters that needed to be flexed, we would have the opportunity to do that. And obviously with the select committee looking at financial technology innovation, insurance space, billions upon billions of dollars worldwide, hundreds of billions of dollars, and we don't play a role in very much beyond our domestic insurance. So there's a lot of opportunity here for us to innovate, and this is an appropriate path for that. That said, we didn't want to restrict innovation related to reinsurance. We wanted to make sure that it was broad, so the statutory provisions are broad. And Mr. Chairman, if I may emphasize 2 things that Representative Co-Chairman Olson was discussing. One, getting to one of the final points about the $500,000 appropriation. Those are existing internal funds, and you can ask the commissioner more about how those operate, but this is not a new appropriation. It's an allowance within their existing funds that are effectively self-funded through fees, that if they needed to use $500,000, they could, and it was a speculative figure. So it's not going anywhere if they don't need it, but it would provide them with the authorization that they requested.
Representative Bear?
Thank you, Mr. Chairman. I'm going to give you a tough challenge. Can you explain to a country bumpkin like myself what type of a service or product might take advantage of this sandbox?
Either one of you, Chairman.
This is an example of something that this might apply to.
So the first good example really was the reinsurance. And I wish we had many more because we'd be pursuing them right now. But the reinsurance has a different structure for what they're looking for investment. We changed that. But also how they engage with consumers. A reinsurance is insuring insurance companies. They don't need the storefront interactions and the oversight over how I engage with my customers because they're a business-to-business relationship. So it was a great example of where our statutes might not be specifically appropriate because even though they're an insurance company, their business model is entirely different from what we think of as a traditional business model. We also have heard about transactional capacities. An early discussion got back specifically into blockchain, which is kind of how it got in our wheelhouse, which is providing for opportunities for transactions and exchange style transactions of policies through blockchain transactions. So tokenizing them and making sure that you can then transact, all right, we're taking this insurance contract and this insurance contract, and we're swapping them, something along those lines, which again is not contemplated by statute. It might be allowed by statute if you dig in, but it's certainly not contemplated by statute. And what we saw with our banking sandbox from a few years ago for financial technologies is that an awful lot of people showed up to talk to the Division of Banking because they thought they needed a sandbox. At the end of the day, they didn't need the sandbox, but they showed up because of the sandbox. And then they had that conversation. Had they needed regulatory relief in some way, that would have been fine, but it's always easier to stay out of the sandbox if you can. I mean, you saw the regulatory oversight that goes into being in the sandbox. If you can operate your business model within existing statute, you're going to want to do that. But we want to provide the flexibility. We want to start those conversations, Representative.
Thank you.
Follow up? Yep.
But can a reinsurance company operate within our current statutes?
Senator Rothfuss?
Mr. Chairman, yes, but for good reason, they don't. The legislation that we're moving through right now, that again is already moved through the House, and did we already pass in the Senate?
This committee saw that. bill.
Okay, excellent. Helps a lot. So those are the kind of changes that the reinsurance sector wanted to see to feel comfortable operating here. So rather than needing the sandbox, we just had the rest of the conversation and addressed that since we had plenty of time available. Now, that said, getting back to the exchange concepts of reinsurance insurance policies, that was an earlier conversation. I literally have no idea if that can be done under statute. Some of the earlier conversations about trying to utilize blockchain and smart contract concepts and implement that, I don't know.
Speaking of limited time, any other questions?
Mr. Chairman,
Yep.
could I just follow up on
Yep.
that? Just
We'll go to Representative
briefly,
Burke. Go ahead.
Representative Mayor, to your question, my co-chairman Rothfuss hinted at this and is very key to the dozens of pieces of legislation that Wyoming has produced in the sphere of blockchain as a whole. Creates an atmosphere that we are open for the right kind of business, but that we are open for business, that we are friendly, and that we are forward thinking on the issues. And that alone attracts a lot of business. As we hold our select committees, we hear from businesses and people that may not necessarily be availing themselves of certain laws that we have built over the last 6 years, but that are intrigued by the idea that that we are constantly looking forward to how can we make our laws more open and more innovative. And the reinsurance example, that's the bill, Representative Ayer, that I presented to this committee a week or so ago. And the point is, in just simply having the conversation in a committee about an insurance sandbox, we attracted companies that then discussed that very specific legislation. And honestly, Representative, that may be an outcome that I think Co-Chairman's correct, that you don't necessarily end up operating inside of a sandbox, but that you realize that maybe there's something else and that Wyoming is willing to work with me on it.
Representative Burt?
Thank you, Mr. Chairman. So obviously I like the idea, but I'm hung up on the appropriations, and I'm glad you brought that up. So it's appropriated the 500,000 from, looks like a fund that insurance already funds, right? So, and again, I'm the new guy, so I'm something all new on this. So does the $5,000 fee, does that go back into basically self-fund themselves? So when they pay the fee, it goes into the insurance regulatory fund, which then where the appropriation comes out to fund the program? Is that how that works?
So, Mr. Chairman, Representative Burt, I guess I'll take the first stab at that. So, yeah, moving forward, any $5,000 application fee that is put into the special account that's created would be used first and foremost to administer the program. Any leftovers can go wherever, but most, at the starting point, one application fee may not cover the complete manpower needed, for example, to review it. So the $500,000 special revenue is their own funds. This is the department's own money already there. And the idea is, yeah, we'll authorize a portion of your seed money to go towards it. And if they never use it, there's no loss to them. It would just revert back and be used for some other fund. And if they get a lot of applicants and they don't need it, then same thing happens.
Further questions? Not seeing any. I know Senator Rothfuss, you might need to run back to the Senate. We might take 5 more minutes to go through the bill. Department, you're neutral on the bill. Any further comments or thoughts? Mr. Rude, go on up, or Ms. Johnson, either one. Welcome, Commissioner.
Thank you very much, Chairman Zwanitzer. Committee, with me is Ms. Johnson, our Deputy Commissioner. I am Jeff Rude, the Commissioner. I'll just be very brief. Time is tight. We were approached by Blockchain on this bill, and we'd worked fairly hard on it in the past interim. We're neutral on the bill. We note that, I've talked with commissioners in other states that have sandbox legislation. They have been approached with ideas. None have been approved, but they did require analysis. And so that's why one of the things that we wanted an appropriation. So we had the ability to do that. We've actually put out requests for proposals where on just we've spread a wide net on possible innovative topics. And we've got folks there should something come up. It's difficult, as Representative Ayer said. I don't know what I don't know. I don't know what they'll present, but we got to have people out there to look at it. If we do, I'll guarantee you, we in the office probably do not have special knowledge in that area. So we were concerned about consumer protections, and we've covered a number of those guardrails, and we're concerned about accreditation. For those new to the committee, accreditation is where our office has strict compliance with rules, and we are examined by a national organization. And once we have that accreditation, other states can rely upon our work. So for example, we have a domestic insurer that sells in Montana, Colorado. If they can't rely upon our work, they will have to examine that. And that's extensive. For us to be accredited, they trust us and they just trust our work, and they don't have to examine them and save time and money. So I have no idea where the innovation will come from. We'll see. I may have doubts whether something would be approved or not, but we'll look at whatever they present, and we'd be happy to answer any questions about the process or any of your concerns.
Questions for the Insurance Commission? Seeing none. Thanks. Industry, property casualty? Welcome, Ms. Wilkinson.
Good afternoon, Mr. Chairman, members of the committee. Catherine Wilkinson here today on behalf of American Property Casualty Insurance Association. We are opposed to the bill as written unless it is amended. I will be very brief in my comments since you're pressed for time. We're generally very supportive of sandbox bills. However, the way this one is written is too broad, as it would waive essentially, it could waive essentially the entire insurance code. We do understand that that is a may and that there is at commissioner discretion. I would tell you we're very comfortable with the current seated commissioner that he would not waive anything that may threaten the NAIC accreditation. However, that is an appointed position. It does leave it up to a commissioner discretion. A lot of the issues have been addressed in the bill. We were concerned about consumer protection as well as the NAIC accreditation. So we do appreciate the blockchain committee amending the bill so that those were covered. However, we would ask that there are certain sections of the insurance code that could not be waived so that it would be a level playing field for legacy insurance companies that go through several hoops in order to be licensed for that consumer protection. Those sections are anything with authorization of insurers and general requirements, fees and taxes, assets and liabilities, investments, and administration of assets and deposits. Mr. Chairman, I did want to address a few of the questions that the committee had in terms of other states that might have sandbox legislation like this one proposed. The feedback that I received from my client, there are other states that do have them, but a lot of them don't because they already feel like they have the authority and so that this is not needed. One other point of a question that was raised in terms of the funding, I missed this up until now, but I do find it a little ironic that this would, the funding for this, that's an appropriation, as I understand it, comes from the assessment of licensed insurance companies. So one of the things that could be waived were fees and taxes. So it would essentially be legacy insurance companies that are currently licensed that would be funding this innovation. Mr. Chairman, I would propose the committee look at the amendment that you should have before you, which would just on page 4, delete lines 21 through 23. On page 5, delete lines 4 through 8. And again, those are those sections that I had mentioned of the insurance code that we would not like to see waived of the authorization of insurers and general requirements, fees and taxes, assets and liabilities, investments and administration of assets and deposits. And that would make us a little bit more neutral in the bill. So I would stand for any questions you may have.
A little bit more neutral or neutral? You're somewhere between against it and neutral now.
Correct.
Okay, any questions for APCA? Seeing none. In committee, I'm cognizant that we do have the CapCon bill on the floor and it's a lot of amendments that are specific to our district. So and I know we have other testimony coming forward on the bill and other amendments proposed. So if it's okay with the committee, I will just hold it over to the next meeting or next Monday's meeting, depending on PBMs on Friday. Seeing no objection from anyone on that. But you do have the Association of Wyoming Insurance Agents amendments in front of you as well, if you'd like to track those in before our next meeting, and then we can come together and discuss amendments. If anybody else has amendments on the bill, you can go ahead and forward those to the committee. And that'll give us a couple of days to look at them and talk to the sponsors from blockchain about where we might go. So, all right, sorry to do that to you, but